everyone. Thanks very much for coming. It's great to have so many of you with us. I'm starting to think now that webinars are the future, really. There's no venue hire, no travel, hopefully easier interaction using the chat function, and unlimited guests from all over the country. And so what's not to like? Well, if there's one thing that we haven't been short of during the lockdown so far, it's online employment law content, particularly about the nuts and bolts of the furlough scheme. LinkedIn activity has gone through the roof, it seems to me. But what we've seen less of up to now, however, is a focus on those areas where we're likely to see new claims finding their way through the tribunal system, potentially in large numbers. So what we've tried to do is something that we hope is a bit different, and we've endeavoured to bring together the main areas where we anticipate those claims arising. You'll see on the agenda slide those questions that we intend to focus on. So what we plan to do is to give you an overview of those issues for about 50 minutes or so, and then it's over to you to ask any questions you may have or make any suggestions you want to make via the chat function. So without further ado, I'm going to hand you over to Geraint, who's going to talk to you in the first instance about health and safety detriment and dismissal issues.
That's right. Thank you, Douglas, and good morning, everyone. Thanks for being with us for the start of our webinar series. Hope you find this useful. Please keep the dialogue going. We'd be happy to cover any questions that might arise after, and we'll work that out together. As Douglas said, I'm going to be dealing with health and safety detriment and dismissal claims. Now, I think that what we would all agree is that the COVID-19 crisis is a particularly unique challenge to the workplace and to our workforce and to employers. And there's a lot of fear and a lot of uncertainty. As legal advisors, sometimes, if we're being honest, it's difficult to find concrete answers to some of these emerging issues that seem to be changing on an hour-by-hour basis at times. There is directions and there is guidance out there. Sometimes it's not very consistent with itself. But we've got to do our best, and we're going to try to get through it together. We have it on good authority that there are a significant amount of claims going into the tribunal system at the moment. And we've also been told, interestingly, that there are certain types of claims which are going in which are perhaps more than normal. The two main claims that we are hearing are going in at the moment are whistleblowing claims. Perhaps that's a little bit less surprising. But the other category is what I'm going to call the health and safety action type claims. That's Section 100, Section 44 of the Employment Rights Act 1996. Now, these claims, one being automatic unfair dismissal and the other being detriment, perhaps haven't seen the greatest prominence in recent times. A colleague of mine in the employment team at Guildhall Chambers tells me that in the last millennium, they were quite common, but perhaps with the whistleblowing reforms of the late 1990s and then the flow of whistleblowing allowing people up until the later reforms of being able to rely on a breach of a legal obligation of their own contract, perhaps all of that meant that the health and safety type claims certainly played second fiddle for a while. Now, I'm sure we all have experience of being involved in a whistleblowing claim that perhaps has a tagged on health and safety action type claim, but in the shakedown, it tends to get forgotten about or dropped or come up against some particular technical problems. But who knows, maybe it's the time for the health and safety claim to be back in the spotlight again. Now, language is very important when it comes to the statute, and language is very important in this pandemic as well. Look at what the Prime Minister Boris Johnson says about the pandemic. The coronavirus is the biggest threat to this country for decades, and we are not alone. And all over the world, we are seeing the devastating impact of this invisible killer. So very serious and high-level language. And the reason that's important is that when we go over to look at some of the language within the statute, section 100, section 44, we will see similarly strongly worded language. So I'll just flag that up for now. But what about some practical, what are the practical realities out there at the moment? And I'm sure we all have our own anecdotes and picked up on the various news reports. But what about the health worker that works in a hospital who fears for their safety, perhaps because there isn't sufficient PPE provision? That's very, very prevalent in the news at the moment. What are their rights? What can they do about that potentially? What about the non-essential workers who are nevertheless being required by their employers to attend work? What about the train engineer who does a manual job working as a team? Is social distancing really possible? And what are the obligations on the employer in that context? Is it actually necessary for those people to work? Is it possible for them to work from home? Lots of questions about that. What about people that work in a very small environment, perhaps a convenience store? Is social distancing really realistic in that sort of context? And what about teachers? They are essential workers, of course, but teaching has changed quite drastically in the last 6 weeks to become childcare essentially for key workers. So although there might be a reasonable cause for a teacher to be in work, what if they have a vulnerable family member? What if they have other concerns, perhaps the way that they travel to work via public transport, for example? I mean, these sort of questions are perfectly natural at this time. But let's do our best to see if there are any answers out there in respect of that. So a quick brief overview of health and safety activities, first of all. So the automatic unfair dismissal right is at section 100, and the detriment is at section 44. There is also an ancillary right for it not to be used as a reason for redundancy. That's section 105, subsection 3 of the Employment Rights Act. Important to note that it's for employees only, not workers. There is potential for interim relief. And there is a natural overlap and parallels with whistleblowing cases. And I'm sure as we go through some of the examples, you'll be thinking about and comparing and contrasting whistleblowing to a potential health and safety claim. Looking at section 100, and I should say that section 44 is essentially exactly the same. When you go and have a look at it later, you'll see what I mean. There are 6 protected activities. A, B, and BA are related to what I'm going to call health and safety officer type roles within the workplace. Not going to talk about them today. What I am going to focus on are the other 3, subsection C, subsection D, subsection E of section 100. And that relates to an employee raising concerns, leaving work in the face of danger, and finally, E, taking protective or proactive steps to avert the danger. And as you can see there from the language that's used, we're talking about quite drastic action, particularly in relation to D and E. Now, some key concepts. And this is where the language comes in again, and you'll see some of the high level of language that's used here. Circumstances of serious and imminent danger. Perhaps this is another reason why health and safety cases haven't been as common in recent times. Question, are we in different times now? I'll leave that one for you to think about. But nevertheless, despite the high level of language, Harvest Press Limited case says that danger must be construed broadly, and that these provisions aren't to be restricted because at the end of the day, they're about individuals' health and safety. What about reasonable belief? Whose reasonable belief is in play? Well, it's the employees. Now, this point is illustrated here in the Udaha case, which was a judgment of His Honour Judge Richardson in the EAT. And it was argued in that case that the employer's belief was also part of the test. Now, this case involved cleaning behind some machinery that was used in food production. And recently, the machinery in question had been subject to some maintenance work. The employee cleaner refused 3 management instructions to clean behind the units, saying that there were exposed wires and essentially cleaning with water-based products was going to put him at risk of electrocution. The employer argued that the question of reasonable belief, and bearing in mind section 100, section 44 requires a pure objective test, reasonable belief. That's the only question when it comes to belief. There isn't a subjective element to it, apart from in one example, which I'll give in a moment, but park that to one side. Reasonable belief. First step is whether or not the employee had a reasonable belief in the danger. There's a question there that follows. So what about the employer's belief? What if the employer didn't believe that there was danger? And what about the reasonableness of that belief? Well, the EAT says that's the wrong focus. The focus is all about the employee's belief. Question, in the circumstances, was the employee's belief in the danger reasonable? If the answer to that is yes, then the second stage is one of pure causation. Was the dismissal because of the employee doing or saying something in response to that belief? And if the answer to that is yes, then the employer has been automatically unfair dismissed. The employer's belief is irrelevant in that shakedown. Now, obviously, when it comes to litigation, we know that that will be a key battleground, whether or not the employee's belief truly was reasonable. But that is a slightly different point to arguments related to the employer's reasonable belief. What about going away and not coming back? This is the subsection D point about leaving the workplace. Again, Harvest Press case is important on this. Danger, broad construction, not limited to dangers that are inherent in the workplace itself. For example, industrial machinery. The word danger is to be used without any limitation, just as it is in the statute. There isn't a qualification in the statute as to the use of the word danger. So, for example, in Harvest Press Limited, the danger actually emanated from a fellow worker who had threatened physical violence against the claimant in the Harvest Press case. The question is always going to be whether or not the belief of the employee was genuine, and if it was genuine, whether or not it was reasonable, a purely objective test. Now, here are some potential sticking points. First of all, in relation to subsection C, the concerned individual who raises concerns, there is express provision within section 100 and section 44 that the first port of call for those concerns must be the health and safety committees within the particular workplace. The only way around that for the employee is A, if there isn't one, or B, if it wasn't reasonably practicable to go to the health and safety committee. And in all of the circumstances in not going to the health and safety committee, the employee must have been behaving reasonably in doing that. Let's think about that in a healthcare context. It's almost certain that there's going to be a health and safety committee within any healthcare context that I can think of. Not reasonably practical to go there, that's going to very much turn on the circumstances, and perhaps the key aspect to that is going to be time, how urgent the concern needed to be raised, and if that is a factor in it not being reasonably practical. But if anything isn't urgent, then you would question how it wasn't practicable for a health and safety concern to be taken to a health and safety committee, particularly where there is one available. Not only that, but also the means by which the employee makes the concern known is highly relevant. It must be reasonable in all the circumstances. And I know that you're going to be thinking, well, that's not dissimilar to whistleblowing, because obviously the means in which you raise a whistleblowing complaint is also a live issue. I'll come on to that in just a moment, but focusing on the health and safety angle. The case of Balfour and Atchison points this out. This is a judgment of Mr. Justice Elias, as he was in the EAT back in 2003. In that case, it was an industrial dispute on a work site where it was held that there was a genuine and reasonable belief in the danger faced by around 200 industrial workers. How they raised it, though, was to walk. They staged essentially a mass walkout, and it was held by Mr. Justice Elias in the EAT that that wasn't a reasonable means of raising a concern. Interesting case to look into, particularly if there's a group involved. What about protective action? This is subsection E. Now, I mentioned a moment ago that it was a purely objective test as to the reasonable belief of the employee. There are some important subjective elements that can come into it, but only expressly in relation to subsection E. So subsection 2 of Section 100 and Section 44 say that all of the circumstances need to be taken into account when considering whether or not the employee had a reasonable belief, but also took appropriate steps in the circumstances. So things like information or advice that might have been available to the employee is going to be relevant there. Highly fact-specific, but an important caveat nonetheless. And there's also the caveat at subsection 3 that if the proactive steps taken by the employee to avert the danger bordered on negligence, then that could be a separate fair reason for the employer to dismiss or to sanction in the circumstances. So I think as we've gone through that, you'll be thinking, oh, there are some real similarities here to whistleblowing. So why shouldn't I just, put my whistleblowing hat on and just run a claim through that channel? Well, here are some particular pluses and minuses in relation to health and safety that I think it's worth thinking about. First of all, there's no public interest requirement for a health and safety claim. Second of all, concerns themselves are potentially qualifying. And also, it's a question of pure reasonable belief. Let's compare that to the whistleblowing channel. Obviously, public interest is going to be a battleground in lots of cases when it comes to whether a disclosure is truly qualifying or not. There's also the vexed question about information, not going to get into that today. And the belief, well, there is a subjective element to the belief when it comes to testing whether it was reasonable under whistleblowing. What were the particular skills, professional qualifications, knowledge of the whistleblower in question? And of course, as we know, sometimes that can actually cut both ways. A highly specialized, knowledgeable whistleblower can sometimes have that held against them when it comes to assessing whether or not their belief really was reasonable. There's a comparison as well to be made between reasonable means, which is an objective test under the health and safety angle, to whistleblowing, where improper means, for example, the Bolton School and Evans line of authority, where the whistleblowing itself may have been completely legitimate, but the way in which it was done was so beyond the pale that it meant that the consequent action against the whistleblower was completely fair and appropriate in the circumstances. I would suggest that the whistleblowing language is far higher. Improper means is a higher standard than reasonable means of action. And as I've already pointed out, whistleblowing also is available to workers, potentially. So taking this all back to our practical outworkings, our practical questions right from the start. How does this play out? Well, let's take the health worker example first of all, and I gave the example of that health worker being concerned about their safety because of the lack of PPE provision, for example. Well, there are going to be a lot of questions, obviously, which are very fact-specific about that. So, for example, what role is the health worker actually undertaking? Are they in admin within the hospital? Are they a porter? How much face-to-face contact do they get with members of the public? You can obviously compare that quite plainly with somebody who works for in the ICU department or is an ENT nurse, for example. High-risk areas, PPE provision, lack of, is clearly going to be something that will be likely to be dangerous and serious and imminent. So that's going to be a battleground. There's also a public interest question as well that needs flagging up. I mean, we've all been in employment tribunal cases, I'm sure, involving a healthcare context, and there have been a health and safety element to the qualifying disclosure or alleged protected disclosure. In experience, sometimes what can happen is an employment tribunal, being pragmatic, says, well, it's health and safety, it's in the healthcare context, let's wave it through as being qualifying and deal with the real issue here, which is all about causation anyway. I've been in cases where that's happened. But I would say that when you actually drill down on it, the PPE provision point, is it really in the public interest for an individual nurse to say, I am not being protected sufficiently? That's sort of what it boils down to. It's certainly arguable, that's perfectly understandable, but nevertheless private concern. Is that therefore more appropriate for a health and safety type claim than a whistleblowing claim, which it may have been if it was pleaded last year before this pandemic kicked off? It's a good question. What about the non-essential workers, moving on from that? Train engineer, group work, is that really possible or feasible? Is there a whistleblowing element to this, a breach of a legal obligation, the legal obligation on the employer to provide a safe system of work? There appears to be, if the employees continue to be asked to come into work, a breach of that. But then, of course, you've got the public interest question as well. Can it really be said to be in the public interest? I'm sure we could get creative and say, well, it's in everyone's interest for people to be healthy, particularly at this time. But are we stretching it a little bit there? It seems more to be a private interest. Therefore, question, is health and safety claim more appropriate? Perhaps it is. What about a teacher, essential worker, that has a vulnerable family member at home? School says it's fine, we're following all the guidance, we're putting adequate social distancing in place, you will be protected, you're not guinea pigs. So I know a lot of teachers feel like that because of how children are apparently low risk. What about if they go on public transport? Well, in that context, you may have the bizarre situation where both the employee says, well, I'm perfectly reasonable in saying that I'm in danger by increasing my contact with other people who may be carriers of the virus. But the employer might turn around and say, well, we're being reasonable as well. We're following all of the guidance to the letter. You're an essential worker. It's a reasonable request for you to come in. Shona Jolly QC puts it like this. It might be the case that both parties are being reasonable. What do you do if everyone is being reasonable? That's a good question. Where I come down to on it, and I'll finish with this, is, as I described earlier, for a health and safety type claim, the question is generally one of pure objectivity when it comes to the belief. Reasonable belief is the test. And whose belief? The employees. So, where I am with this at the moment is, if the employee has a reasonable belief in imminent danger, and given the language that is being used by our politicians and our leaders and our experts about the situation regarding the virus, and that language in section 100, section 44, being high level, yes, but suddenly becoming more and more relevant, then I would fall on the side of the teacher in that question potentially having a health and safety action claim if they are disciplined for not attending work, taking proactive steps, or even raising concerns. Obviously, these are all very fact-specific, but I hope that that's food for thought. And perhaps maybe to finish, we need to brush up on health and safety action knowledge, because these claims are coming back. I think they're going to come back big, and we need to be prepared for them. I hope that was helpful. I'll hand over to Douglas now for the next section of the talk. You're on mute.
What I'm going to speak to you about first are claims likely to arise out of furlough and/or redundancy decisions. So let's set the factual scene to begin with. We've got the vast majority of people at home. We've got an employer which is much less active, there's much less money coming in, simply cannot afford to keep paying all of the staff. For example, a widget making factory. Widgets cannot currently be made, or only to a very limited extent because of social distancing measures. Some aspects of the business will still be operational, supplies, planning, some finance and administration functions, for instance. The employer doesn't know when demand for widgets is going to pick up again or how quickly. The employer simply needs to run on a reduced staff to keep operating during the restrictions. It will, of course, need more staff in the future as restrictions are eased and business picks up again. I should say that the factual background assumes, of course, that any furlough decision will be because of the coronavirus pandemic. The Treasury direction makes clear that the need for furlough has to arise out of the pandemic circumstances and not for other reasons. So we operate on that premise. And it seems to me that there are going to be two main scenarios where an employer will want to make use of the furlough scheme. The first one is where the employer needs, as much as I've described a moment ago, to operate with a reduced staff. It needs to select those who are going to continue working, and everyone else is going either to be on the furlough scheme or alternatively made redundant. In that situation, at the end of the furlough period, it's likely that there will be a redundancy exercise, and many of those employees who were on the furlough scheme will find themselves being made redundant at that later point, not necessarily all of them, depending on the circumstances. The second scenario is different. It involves an employer not in such a dire situation, perhaps in a service industry which is more easily adapted to working from home. There are no particular plans to make any redundancies either immediately or later on, but inevitably profits are down because activity has reduced. So the employer wants to concentrate or consolidate the available tasks amongst a smaller number of employees during the restrictions and to save some money by furloughing some people. We'll start with the first scenario. Now, the thrust of this situation, of course, is that what is going on is that the employer is having to select who will stay at work, albeit probably at home. This will obviously apply to varying degrees up and down the country, depending on the business's circumstances, ranging from a situation where the staff needed consists only of a skeleton staff at one end of the spectrum, up to the other end of the spectrum, perhaps the majority of the workforce staying at work. And of course, the extent to which redundancies will be needed at the end of the furlough period will also vary from basically all furloughed employees, where the situation is particularly dire, up to, at the other end of the spectrum, only some people being made redundant. But either way, it seems to me that there are effectively two selections happening. In the first instance, the employer is having to select who will stay at work, and then later on, after the furlough period, is having to carry out a second selection exercise for redundancy. Now, at stage one, what is actually happening? It seems to me that if the position is that the alternative to an offer of furlough is going to be immediate redundancy, then what in practical terms is happening is that the non-selection to stay at work is effectively a selection for immediate redundancy, subject to accepting an offer of furlough instead. So I would suggest that objective criteria need to be used for that selection exercise in the usual way. It's not likely to be a problem where all that's needed is a skeleton staff, because that skeleton staff will pretty much be dictated by business reality. Those people are going to select themselves most of the time. But the more the situation moves away from that position and towards a state of affairs where a greater number of the employees are going to be remaining at work, and therefore finer distinctions are having to be drawn as to who stays at work and who does not, the greater the scope there is for disputes and for people to want to challenge the decisions that are being made. So what are the potential claims that might arise out of this situation? Well, of course, until there's actually a dismissal, there's not going to be an unfair dismissal claim. But in this scenario where everyone who doesn't stay at work is either redundant or asked to go on the furlough scheme, what if an employee refuses an offer of furlough scheme, an offer of access to the furlough scheme, and gets made redundant? What then? Well, in this scenario, it's difficult to see that dismissal being unfair. There would really need to be a serious problem, it seems to me, with the criteria used to select those who are staying at work, or some other serious issue as to unfairness in the process, applying all the usual law. Nothing particularly novel about the legal question in this situation. Someone might legitimately claim about being furloughed if it seems to them to be irrational for them to have been selected instead of someone else, John Smith down the corridor, for example. But unless there's some proper meaningful basis for asserting that, an offer of furlough is eminently within the range of reasonable responses, it seems to me. Of course, any subsequent post-furlough redundancy process will need to be conducted fairly, in the usual way, and in a non-discriminatory fashion, applying again all the usual law. That you want to take particular care in respect of female employees returning from maternity leave into a redundancy exercise, for example, bearing in mind Section 99 of the Employment Rights Act and Regulation 10 of the Maternity and Parental Leave Regulations. But you would be doing that anyway. There's nothing particularly new to think about here. But what about other sorts of claims that might arise out of being asked to go onto the furlough scheme instead of being kept at work? In what circumstances might someone be unhappy about an offer like that? Well, the obvious situation is in the case of high earners, because going onto the furlough scheme in those circumstances is going to lead to a substantial pay cut, self-evidently potentially a detriment for discrimination purposes. Even leaving aside issues of reductions in pay, there may simply be a resentment over somebody else being chosen to stay at work rather than the putative claimant. Anecdotally, I've encountered several people who object to the idea of being furloughed or are concerned about it because it's seen as a precursor to being made redundant. There's a perception that being asked to go on furlough means that your card has been marked and that in due course you will be made redundant, and there's therefore an understandable reticence about agreeing to it. You might say, in terms of the detriment question, that perhaps even if there's no particular pay cut involved, perhaps even because the employer voluntarily chooses to top up the furloughed employee's pay, could there be a detriment nevertheless? There may be a suggestion that the employee is less necessary than another employee as a result of being asked to go on the furlough scheme, bearing in mind the Shamoon threshold for detriment and the emphasis on the perception of the worker or employee. I mean, it's an open question, but it's not impossible that being asked to go on the furlough scheme might amount to a detriment in those circumstances. But certainly when we're talking about substantial pay cuts, that's beyond question, it seems to me. So if you're in a situation as the employer of having to choose between an employee who's going to be kept at work and somebody else, then a risk of discrimination claim is going to arise if that choice involves discriminatory factors. The most obvious candidates are sex discrimination and disability discrimination, I should think. So how would that come about? Well, one can quite imagine an employer perhaps not taking advice, reading the guidance and so forth, seeing that it's possible to furlough an employee on maternity leave, for instance, making assumptions about the need to do that, the desirability of doing that. They might make assumptions about a woman's ability to work at home if that she has young children and it's perceived that she'll be responsible for caring for those children, unable to do her job properly, and similar assumptions being made about it's assumed will not have such difficulties. That's obviously going to give rise to potential for direct discrimination claims. There may be a requirement operated by the employer that employees need to be available at all times during the working day, and it may be on the evidence that there is an issue for female employees in the workplace as to their ability to comply with that requirement, because there is evidence of substantial number of women disproportionately in fact having childcare issues. So there may be indirect discrimination in such circumstances unless the PCP can be justified. That will lead to questions being asked about how much of a need there actually is for the work to be done at specific times, for example. What about disability? well, it's the same concept, essentially. If an employer is making assumptions about a disabled employee's ability to do his or her work at home, similar issues are going to arise. It may be, for instance, that the employee usually has reasonable adjustments in place in the workplace, and the employer assumes, well, without those, they're not going to be able to work effectively. I'll put them onto the furlough scheme. As a result, well, of course, the duty to make adjustments applies as much to an employee working at home as to an employee working at the workplace. So there may be reasonable adjustments claims, as well as other types of disability discrimination claims based on those sorts of assumptions. Now, if you're a claimant, potential claimant in these circumstances, you're likely to want to present the claim about the furlough selection, if appropriate, early doors, because it will lay down a marker for any subsequent redundancy exercise that may take place. And of course, if any detriment occurs as a result of making the claim or intimating it, there will be a victimization claim available. I would suggest that the reverse situation is perhaps not so likely to produce potential claim. So, for instance, if volunteers are sought in the first instance for going onto the furlough scheme and people actively want to be furloughed, then it's difficult to see any such person wanting to bring a claim or it being successful if they were to do so anyway. On the other side of the coin, of course, those who have to do their jobs as a result of not going on the furlough scheme in those circumstances are contracted to do so. They may perhaps be less than happy that a colleague next to them is at home being paid at least some of their pay for not doing anything whilst they're having to work, but ultimately they're contracted to do their jobs, and if they have to do that, they have to do that, it seems to me. What about the second scenario? This is a bit different. You'll recall we're concerned here with an employer who doesn't especially need to make any redundancies, is really only concerned with saving money. For instance, they might seek to do so if they have, for example, a high-paid female employee who is on maternity leave on a generous maternity leave provision with some full pay maternity leave coinciding with the furlough period. There might be a desire to save some money by putting an employee like that onto the furlough scheme rather than having to pay them full pay when it would seem not to be entirely necessary. But there are serious doubts looking at the terms of the scheme as to whether that is legitimate. So if you look at paragraph 2 of the Treasury Direction, for instance, it's careful to describe the purpose of the scheme as to reimburse employers for who are incurring costs of employment in respect of furloughed employees arising from the health and social and economic emergency. Well, if an employee, for instance, is on maternity leave already, can it really be said that those costs arise from the health and social economic emergency? I'm not sure that it can. Paragraph 2.5 goes on to emphasize that abusive claims will not be allowed. It's important to keep that in mind. Moreover, the guidance, separately from the direction, describes the point of the scheme as being to provide assistance if you as the employer cannot maintain your current workforce because of COVID-19. So the indicators are pointing away from the idea that you might be able to use the scheme simply to save money. Further, the other terms of the direction are to similar effect, particularly when we're concerned with the example that I gave at the beginning of this section. So paragraph 6 of the Treasury Direction defines furloughed employees as employees who've been given instruction to cease work by reason of circumstances arising as a result of the pandemic, in broad terms. Well, can you be instructed to cease work if you're already on maternity leave or perhaps long-term sick leave, for example, not working, arguably? So can you be instructed not to work in those circumstances? If you can't, then you're not a furloughed. You can't be a furloughed employee for the purposes of paragraph 6. But the guidance, the most recent guidance, also says you can claim through the scheme for instance, enhanced earnings-related contractual pay for maternity or parental leave. So in that particular instance, there is, it seems to me, inevitably a conflict between the guidance and the Treasury direction. How that conflict is to be resolved is difficult to say. You would assume that since it's HMRC that pays out the money, then HMRC will follow its own guidance until such time as the Treasury tells them not to or to change the guidance. So having noted the conflict and uncertainty, I'll proceed on the assumption that it is possible to furlough employees in those circumstances. Now, indeed, problems are likely to rise where employers look to furlough higher earners in these circumstances. So, for instance, the higher earner who's on maternity leave with generous full pay maternity pay for a period, for example, they would appear to be to the unthinking employer a kind of low-hanging fruit in terms of saving money by asking them to go onto the furlough scheme. Now, if an employer adopts an approach essentially of targeting such employees for offers of furlough, then this is going to create problems. We have to remember, of course, that in this scenario, we're not in a situation where essentially everyone is either being furloughed or made redundant, subject to some people who are being selected to stay at work. We're concerned here with a more individualistic situation. So as the slide suggests, a woman in those circumstances on at least 60,000 a year is going to be taking a 50% pay cut in those circumstances. Obviously a detriment, as I've previously noted. Now, there may well need to be scrutiny of the circumstances in which the employee's agreement to going on the furlough scheme is obtained. We'll come on to the need for agreement, but there may be evidence of some pressure being applied, and is the request in itself, in all the circumstances, capable of amounting to a detriment, or may very well be. And as I say, we need to scrutinise the circumstances of the request and whether any pressure was applied. If the evidence can bear out the detriment proposition, then targeting of employees in these categories is obviously going to amount to Section 18 discrimination. Similar issues might arise in respect of those on long-term sick leave. I'm thinking, of course, about those employees on long-term sick leave who satisfy the test for disability under the Equality Act. But again, here, there's doubt when looking at the rules of the scheme as to whether such employees can necessarily be furloughed. Now, if you look at paragraph 6.3 of the Treasury direction, terms of it are quite clear. The principle is that where statutory sick pay is payable or liable to be payable, whether or not a claim to SSP is actually made, the employee cannot be furloughed. So wherever there's an entitlement to SSP, that's enough, according to the direction, to prevent that employee from being furloughed. but the guidance says something different. It suggests that employers are entitled to furlough employees who are being shielded or are off on long-term sick leave. Now, that's an obvious conflict, it seems to me, unless the terms of the guidance are construed in a particular way, which is to suggest that employees who have exhausted their SSP entitlement can be furloughed if they remain on long-term sick leave thereafter. It could mean that. Difficult to say. The provisions don't fit together. There may need to be updated guidance yet again. But if we assume that the guidance is right, an employer can choose to furlough those on long-term sick leave, in theory, the employer can take them off sick pay and choose to put them on the furlough scheme again to recover the costs of contractual sick pay. If employers can do that and do it in an opportunistic way by targeting those employees who may be on full pay, sick pay, for instance, there may well be disability discrimination claims of the sort that we're familiar with. So, for instance, Section 15 claim, the employee would be chosen because of their absence, which is disability related. The issue will then all be about objective justification. It is being done to save money when no redundancies have been envisaged. Then it's difficult to see how such action would be justified. Even on the pessimistic view of the interaction between the direction and the guidance, you could still have employees who benefit from the sort of long-term sick pay scheme that we're all familiar with, 6 months full pay, 6 months half pay. If they're earning anything over 60,000 during the half pay period, after the 28 weeks of SSP are exhausted, employees in that situation who earn gross anything over 60,000 are still going to be taking a pay cut if they're asked to go on the furlough scheme. So they would potentially benefit from a Section 15 claim as well. We also have to keep in mind those who are selected to stay at work during the restriction period, the period of the furlough scheme, which is likely to overlap. It may be necessary to vary the contract if the terms of the contract are such that the employee cannot be required to work from home. It's perhaps difficult to envisage employees refusing to work from home in circumstances where they're aware that redundancy may be on the cards. The business is just generally difficult. Perhaps not so many employees will take issue with that, but they might do. There may be health and safety concerns. Working from home, usually a risk assessment will be required. Regulations have to be complied with in relation to the workstation. There may be other issues making it difficult to work from home, childcare issues, issues to do with disability, for example, that may very well be reasons for refusing or wanting to refuse to work from home. So in those circumstances, the employer might well choose to offer them access to the furlough scheme instead, or if the employee refuses that, it may be that redundancy is the outcome. But what I would suggest is that in any eventual redundancy process that might take place after the furlough period is over, it would be unwise to give any kind of priority to those who remained at work during the interim period, because there may be particular reasons related to protected characteristics or health and safety issues, for example, why others who did not stay at work were at home or on the furlough scheme. So just beware about giving any kind of priority. Moving on then, I want to discuss for a moment the implementation of furlough and its effect on the contract of employment and employees' wages. Now, it's very clear, I as a matter of contract that entering the furlough scheme will be a contractual variation, will have to be done by agreement. But where there's an issue about whether the notification has to be given to HMRC by the employer for the employer to recover its monies, has to be a notification of or written agreement involving signature by the employee and so forth. But we're not concerned with that here. I'm concerned with the contractual position. It must be an agreed variation. We have happily some authority, recent authority which touches on these issues, the Carluccio's judgment, which you're most likely aware of. Mr. Justice Snowden was not prepared to say that those employees who did not answer a variation letter had agreed to its terms by silence, especially in circumstances where the letter gave no indication that agreement would be inferred from silence. So in future, you may want to take the precaution of sending the letter in a way that enables you to evidence that it's been read, so a read receipt by email, for instance, or sending the letter by recorded delivery, for example. Most employers are probably going to want to include an express term as well, making it clear that what the employee will be entitled to is limited to what Revenue and Customs will reimburse the employer. So, in other words, to limit the employer's liability to what is received by that route. Otherwise, it seems likely to me that the employee will just be agreeing to receive up to 80% from Revenue and Customs or via Revenue and Customs, but won't be agreeing to forego the remaining 20%, for example. The express term is going to be necessary to avoid liability to pay the remainder. What sort of claims might arise out of these circumstances? There are a couple of situations which spring to mind. For instance, in circumstances where you have this limitation of liability clause, what if the employer messes things up and doesn't actually pay the employee the full 80% to which they're entitled, perhaps because they failed to take into account various eligible supplementary payments which should be factored into the calculation? Or in those circumstances, it seems to me that there may very well be an implied term that operates. By analogy with permanent health insurance cases and ill health retirement cases that you'll be familiar with. So Briscoe and Lubrizol, of course, deals with the implied term to the effect that where an entitlement to benefits under a PHI policy exists, there's an implied term that the employer will not dismiss the employee so as to deprive them of those benefits. Similarly, in Hague, it will be unfair to dismiss an employee in circumstances where they would be entitled to the benefit of the ill health retirement scheme. Instead, dismissal depriving them of those rights. So they both concern dismissal, but by analogy, it seems to me that what would be going on in this situation is that the employer would be depriving the employee of the rights to which the employer had expressly agreed they were entitled. There may very well be an implied term, which means that a wages claim could follow on the basis of that breach of contract for the employee to recover the difference. If that's right, then there may be an incentive to focus on higher paid employees for offers of furlough. If they're getting well over £2,500 a month, for example, the situation is easy because there are no problems of calculations, there's a low administrative burden. Also, the biggest saving for the employer, arguably less risk of discrimination claims as well, because there would be a clear objective reason for choosing those employees, being the fact of their higher salary. So something to think about there. But another situation is even worse, where the employer persuades the employee to go onto the furlough scheme, but then includes this express limitation of liability clause, but it subsequently turns out that Revenue and Customs won't pay out for some reason, perhaps because the employee actually is not eligible in some way. Can the employer say, sorry, pointing to the clause, nothing is due because Revenue and Customs won't pay us anything? So, despite what we said to you, you're not going to get paid anything during the period that you've had off so far. There will be a delay between applying for payments and being informed of the outcome of the application. That time that you've not been working, we won't pay you for that. You'll either have to come back to work if you want to be paid, or otherwise you'll simply not receive anything. Again, I would suggest that the position is not as clear-cut as it might seem. There may be an argument that full pay will be due during that period. The claimant only agreed to the variation on the basis that monies would be paid under the scheme. They're otherwise ready and willing to work, which is the litmus test following Miles and Wakefield. And it's helpful to point to some other wages cases involving employees remanded in custody, for instance. So in Burns, employees remanded in custody, there's eventually a conviction. So in that situation, the reason why the employee was not able to work was their own fault, wages not due. The converse is also true, however. In Knowles, for example, eventually an acquittal. So the reason for not being able to work was not the employee's fault. They were ready and willing to work, wages due. So by analogy with those cases, I would argue that it may very well be that an employer who persuades an employee to go onto the furlough scheme in those circumstances may very well wind up having to pay wages in full. The only reason the employee would not have been working is because of what they were told by the employer. Otherwise, they would have been ready and willing to work. It's not their fault that they were not working, unless, of course, you point to the fact that they agreed to the furlough offer, but under false pretenses, I would suggest. So there's likely to be a decent argument there for recovery of full pay. Finally, I'm going to look at the interaction between TUPE regulations and furlough. Now, the Treasury Direction has happily made clear that transferees, for instance, can inherit furloughed employees and continue to leave them on the furlough scheme. And similarly, they can inherit non-furloughed employees, but also then choose to put them on the furlough scheme post-transfer. I would say, however, there's some uncertainty as to whether the same is true in relation to service provision changes. The language in the direction appears to be targeted at business sales only. That may be an oversight. It may be deliberate. There doesn't seem to be any obvious reason to exclude service provision changes, given that the apparent thrust of the provision is to ensure that employees can still be furloughed, even though at the relevant date they were on somebody else's PAYE system. Also, Carluccio's, as you'll be aware, makes the important point that administrators can take advantage of the furlough scheme. What are the claims that might arise in these circumstances? Dismissals pre-transfer. Well, if you don't need to do it because you have the furlough scheme available as a cost-free option, then it's hard to escape the conclusion that what you're really doing is trying to make the business more attractive for a sale. Therefore, the dismissals will be because of the transfer, liability will transfer to the transferee. That's the corollary of the Kavanagh and Crystal Palace situation. What about post-transfer dismissals, well, it's essentially the same reasoning. The dismissals are likely to be automatically unfair if they happen soon after the transfer, in circumstances where the furlough scheme would have been available as an alternative at no cost. It would tend to suggest that the sole or principal reason for the dismissal is the transfer itself and not an ETO reason. It's conceivable that there might be an ETO reason in an individual case if the employer, the transferee, knows that in due course they're going to be redundant anyway because of restructure that they have in mind. But even so, there's going to be an increased risk of unfairness in that situation if the employee is not able to participate in the selection exercise, and if they've been deprived of the opportunity of a period of furlough which doesn't cost you anything. It seems to be outside the range of reasonable responses, in my view. Maybe breach of contract issues as well. There may be a possible implied term here that you simply shouldn't dismiss an employee where you've got the option of keeping them on the furlough scheme at no cost. That's pretty directly a Briscoe and Lubrizol or First Great Western and Hague situation. At the very least, the damages in that claim will be the value of the lost furlough income if ultimately there's a termination. There may be wages claims, for example, in the alternative, depending on the circumstances. You also have to comply with information and consultation obligations. This may present practical problems. How are you going to administer the election of representatives, for example? What you may want to do, if you bear in mind Regulation 1311, which enables the employer to avoid some of the obligations if the employees fail to respond within a reasonable time to an invitation to elect representatives. So a tactic that has been successful in the past, especially under tight time constraints, is to write to the employees, giving them the relevant information in the letter directly, expressly inviting the election of representatives, informing the employees that should they take up that option, then the request will be complied with, but the representatives will be given the information that the employees have already been given in the letter. And 9 times out of 10, the employees won't see any point in electing representatives. You give a reasonable amount of time for the answer, explaining that silence will be taken to be an indication of not wanting to elect a representative, and in that way you can comply with your obligations. Similarly, there may be issues in relation to Regulation 13.9, the special circumstances defence. In my view, that's less likely to help employers in these circumstances. Is the fact of difficulty in contacting people enough to constitute special circumstances so as to avoid the obligations altogether? I think there must be significant doubt over that. If employees are already on the furlough scheme, of course they're not allowed to work. If that's the case, then there may be an argument that it's not permissible to ask them to reply to letters asking them about electing employee representatives, for example. I think that's a bit of a stretch, really. And it seems to me that the Regulation 13.9 point is probably not going to be of much assistance. But we'll see. Could be wrong about that. Who knows? The last point is the potential for post-furlough variation. So we've got a situation where there's a transfer, employees are on furlough for a period. Is there an advantage to a transferee in those circumstances arising out of the coronavirus pandemic? Well, possibly there is. The usual rules will apply to post-transfer variations, of course. If the transfer is the principal reason, the variations will be void. Where there's an ETO reason entailing changes in the workforce, variations will be permissible. Those changes in the workforce may include changes to the place where the employees work. So variations of that sort will be permissible. But these are all fairly standard considerations. What is interesting to me is Regulation 9, because even after all this time, since the latest iteration of the regulations, Regulation 9 remains completely untested in the appellate courts. So the benefit of it is that if the transferor rather, is in administration at the time of the transfer, then it's possible to agree permitted variations via, in inverted commas, appropriate representatives under Regulation 9.2. Those representatives don't need to be elected representatives. They don't need to be union representatives. They just have to be people given authority by the assigned employees. So given that there are likely to be a lot of administrations, I would suggest an area where we're going to see increased activity perhaps is in relation to Regulation 9. So watch out for that. That's the last aspect of what I wanted to talk about. I know that Geraint now is going to finish off by discussing collective consultation obligations.
Yes, thanks, Douglas. And just to finish up, really, a thought that Douglas has started there. What is furlough and what is redundancy, and how do they marry together, particularly in relation to obligations of group consulting? There's collective consulting that needs to happen. So here's the question. Is a duty to consult under Section 188 of the 1992 Act engaged when furlough is proposed? Well, maybe we need to ask the bigger question to start with is, what is furlough and why is it being used? Douglas gave you a couple of examples there. There was scenario 1, scenario 2. Scenario 1 being a case where redundancies were essentially going to happen if furlough couldn't be agreed. Scenario 2, slightly more nuanced, perhaps slightly more tactical, different reasons as to why furlough might be sought to be employed. But let's rewind the clock a little bit, and it seems like a long time ago now, but it wasn't really. On the 20th of March, when the Chancellor, Rishi Sunak, presented the job retention scheme, we call it furlough, but it's about retaining jobs. And he said this, and as we crowded around our television screens and our radios to hear this momentous announcement, for the first time, the UK government was going to step in and pay workers' wages. He made a couple of really interesting points. First of all, he said employers will be able to contact HMRC for a grant to cover most of the wages of people who are not working but are furloughed and kept on payroll rather than being laid off. And he went on to say that means that workers in any part of the UK can retain their job even if their employer cannot afford to pay them. Now, it seems to me that furlough and redundancy must really come hand in glove for it to truly be job retention scheme. If there's no work to do, or if there's no money to pay workers, is redundancy inevitable? Is it a but-for question? But taking it back to the point that Douglas made about scenario 2, I mean, there might be numerous reasons why an employer might want to take advantage of the furlough provisions that aren't necessarily in contradiction or contravention of the guidance that's out there. Now, there's a lot of legal chatter out there at the moment, as you can imagine, and it is difficult to find a consensus on the question of whether or not the redundancy obligations in relation to consultation kick in if furlough is being thought about. As we know, under Section 188, proposed redundancies is the trigger point. Let's contrast a couple of different situations. If there's, if a company gets its workers around the table, say, and says that we need to agree a variation of terms here. We need to take cuts. We need to cut wage bill. We need to ask you to drop your income in a similar way to some Premier League football clubs have done. If you get people around the table and there's an agreement to a variation of terms, then it's possible that redundancy hasn't been proposed at that stage. Obviously, it's going to depend on the circumstances. If there are unions involved, then by all means that would be best practice to get them involved. But if it's just an intention to seek an agreement on a variation of terms, then the redundancy proposal hasn't been triggered. But what if furlough cannot be agreed through those means, or the cost savings sought? What is the plan? Well, for a company that is seeking to say it is a legitimate furlough in line with retaining jobs rather than laying people off, then Section 188 suddenly looms large as potentially being engaged, particularly, of course, if we're talking about a situation with 20 or more people. The question is, what is the plan? If furlough cannot be agreed, what is the employer's strategy as a next step? There are also practical problems, of course. Douglas touched on this already, so I won't go over them in any great detail. But how would you hold elections, brief the workforce, and even consult itself? Some industries and companies will find it far easier to hold Zoom or Facebook Live meetings than others. What if we are dealing with a manual type of industry where everyone tends to work in a factory and there isn't necessarily the provision of IT when that worker goes home? Are companies going to be staring down the possibility of protective awards because they've inadvertently walked into a pseudo-redundancy situation by simply exploring furlough? My view is that actually companies need to be very alive to this, because as I say, furlough redundancy for me goes hand in glove. And I think that an artificial way of trying to separate the two, it goes against the founding principles that the Chancellor set out and can be found in the directions. I accept that the guidance is somewhat contradictory, perhaps, on this point, and that's maybe why there is a lack of agreement across some of the legal chatter and take on this development. But maybe the practical point to draw out is we need to brush up on the special circumstances defence, which is available at subsection 7 of section 188, where it's not reasonably practicable for the employer to comply, and the employer took all such steps towards compliance that are reasonably practical in those circumstances. Now, word of warning, it's been restrictively applied in the case law, and the onus is always going to be on the employer to prove that they did take all reasonable steps to avoid problems of protective awards, etc. So we're very grateful for you to having spent your time with us today. We would be very happy to pick up any questions that are arising from today or have cropped up. Similarly, if you have any questions that arise after today that come to you, then please do get in touch, and we'll be very happy to field those. But other than that, I think it's just left to say thank you and all the best, and do take care.